Good afternoon. My name is Steve Blake, and I'm an attorney at the Blake Law Firm. And we are here today to provide a short webinar on managing conflicts between CC&Rs and state laws regarding ADUs. And Andrew Hall, who is an attorney and senior counsel at the Blake Law Firm, will be giving the presentation today. So I'll let Andrew take it from here. Thank you.
Thank you, Steve, and thank you all for tuning in. As Steve mentioned, my name is Andrew Hall. I am senior counsel for the Blake Law Firm. And today I'll be discussing some of the recent California legislation paving the way for the creation of accessory dwelling units, or ADUs. There's been a substantial amount of ADU-related legislation over just the past couple years alone. In 2019, for example, there were 18 ADU-related bills passed, many of them taking effect in 2020 and 2021. We could spend hours going through the impact of these bills and the implications statewide, but this webinar will focus specifically on the intersection of this ADU legislation and HOAs. So you may be asking yourself, why ADUs? Why is California looking at ADUs as a big part of its thrust to create affordable housing? Well, there are several reasons that the state points to. They're low cost to create. They take space from existing primary residences, so it's not necessary to acquire new land. We all know that land in California in particular is extremely expensive. So taking the acquisition of the land itself out of the equation is a substantial benefit to homeowners and the creation of that affordable housing. There's already dedicated parking and infrastructure in place. It infills areas closer to jobs and amenities. So rather than building in more rural areas, we're able to infill in the more suburban and urban areas to get people closer to jobs, grocery stores, schools, etc. It creates a rental stream for homeowners. And in particular, in the past year, we've seen an uptick in the construction of ADUs to be used as home offices or even classrooms for homeschooling. So we anticipate that the numbers on both the applications for ADUs and the construction of ADUs will continue to rise. As with any law, though, these new laws have created a great deal of uncertainty, especially with regard to homeowners associations, or HOAs. HOAs are governed by their own covenants, conditions, and restrictions and other governing documents. Sometimes these governing documents are decades old. So there's often a conflict between these older provisions in the governing documents and some of the newer laws that need to be rectified. So a little bit of background, and this might help explain why there's such an emphasis on HOAs as a potential avenue for creation of affordable housing. In 2019, 2020, California led the nation in both the number of HOAs at approximately 49,000 and the total residents in those associations at just a shade over 14 million. So there's a substantial number of both associations and residents. And if you have HOA governing documents that exclude ADUs from being built within the communities, that's a huge chunk of housing that is immediately out the window. So we can see why the HOAs are a bit in the crosshairs of the state in outlawing any outright prohibitions to ADUs within these communities. So I want to take a step back and look at some of the more recent general ADU-related legislation, just to give us some insight into where some of these HOA laws are coming from. So the first and most significant legislation is found in Government Code sections 65852.2 and 65852.22. And these are two new and extremely robust statutes. There's a ton of information in these statutes outlining what local agencies can and cannot regulate. Some of the standards that they can regulate are parking, height, setback, lot coverage, landscape, architectural review, the maximum size of the unit. And this list is by no means comprehensive. There's a laundry list of items found within these two government code sections that if you have any interest in pursuing an ADU that you want to take a look at. Another significant provision in 65852.22 in particular is that ADUs are permitted to be rented out. And this is where the affordable housing comes in. So there can't be any restrictions on renting out these ADUs once they're built. So Civil Code 5751 and 4741 are more HOA related ADU statutes. Civil Code 5751 is a doozy. It forbids HOAs from unreasonably restricting the construction or use of an ADU if otherwise compliant with the government codes I just mentioned above. So if you're sitting there and wondering, well, what is an unreasonable restriction? I can assure you you're not alone. I'll have more on that in a moment. Civil Code 4741 prohibits an HOA from unreasonably restricting the rental of an ADU within the HOA community, though it may prohibit transient short-term rentals for a period of 30 days or less. And as significantly, HOA governing documents must conform to these new rental requirements no later than December 31st, 2021, or it may be liable for damages and a civil penalty. So if you're in an HOA where you have provisions within your governing documents that outlaw or restrict the ability of a homeowner to rent out an ADU, you'll want to take a look at those and revise those as quickly as possible. Another significant bill is Senate Bill 330. This is another ADU related piece of legislation that expedites building permits, limits fee increases, and bars local governments from capping the number of homes or ADUs that can be built. Again, the purpose of this is to eliminate the red tape and really encourage and facilitate the quick building of these ADUs. So going back to this unreasonable restriction question, we know from the above statutes that an HOA cannot unreasonably restrict the construction of ADUs. Well, what does that mean? Good question. What it does mean is that though they can't unreasonably restrict them, they can add reasonable restrictions onto the construction of ADUs within the community. What's a reasonable restriction? Fortunately, Civil Code 5751 gives us a little bit of insight, though it's still not entirely clear. Reasonable restriction is defined as one that does not unreasonably increase the cost to construct, effectively prohibit the construction of, or extinguish the ability to otherwise construct an ADU. Why is this potentially problematic? Well, as we saw earlier, there are thousands of HOAs in California and millions of people in HOAs. HOAs are very unique. They vary in size and location and many other factors that make it difficult to put a one-size-fits-all or cookie-cutter definition of reasonableness into place. Reasonableness is a completely subjective term, and what may be reasonable for one HOA might not be for another, and vice versa. So it puts a lot of the burden on the HOA, and in particular its board and governing bodies, to really dig in and evaluate this reasonableness question. Aside from what's reasonable and what's unreasonable, these new laws create some significant potential financial implications for HOAs. HOAs are designed with a certain number of residents and structures in mind. HOAs then assess their members based on these numbers. So if you have an ADU that is built and rented out to new people, you're obviously seeing an influx of persons within the community. What then may an HOA do? May it assess these new renters? Can it assess the owner of the ADU? Or will this be viewed as an unreasonable restriction on the ADU? The inability or ability of assessing these individuals could have huge implications down the line. For example, the influx of persons within the community could put great strain on common areas. Obviously, the more people that are accessing these areas, the more wear and tear and maintenance is needed on these areas. And the HOA needs money through assessments to be able to address them. So if they aren't able to get them through the ADU owners or renters, it's likely going to come out of the pocket of the other members, which is not something that will likely make the other community members too happy. So we could see a potential conflict there. There's also the issue of liability. What if you have a renter that is accessing a common area and gets injured? Can the renter then pursue recourse against the HOA? Again, potentially. And the same question with insurance. So are HOA insurance premiums going to increase to account for additional persons within the community, and along with that, the increased risk associated with that? Another potential cost is through Civil Code 4741, which requires HOAs to amend their CC&Rs. CC&Rs are often required to obtain a member approval for any amendment to them. Thus, what happens, albeit a far-fetched scenario, that a membership decides that they don't want to implement these new laws, or that they can't get a quorum to vote on them. Again, far-fetched, but it does potentially put the HOA in a difficult position where they're not able to amend their CC&Rs to comply with these new laws. And these laws are also likely to create a higher risk of lawsuits for HOAs, which in turn require attorney's fees and increased expenses. For example, if you have a homeowner that wants to build an ADU and a neighbor objects, one side is not going to be happy with the decision. Either the applicant or the opponent are not going to be happy. And they're going to be looking to the HOA to explain their decision and potentially to litigate the issue. So we can see down the pike increased mediations and even potential litigation coming down the road. So if it seems like there are more questions than answers, it's because there are. These questions will remain open until there's either further direction from the legislature to fill in some of these blanks, or that the issues are hashed out through the court system. Given the backlog of cases right now due to COVID, it's likely years until we have any sort of decision on these issues from a legal standpoint to help guide us. Until then, here's what HOAs can do to protect themselves. Ensure governing documents are compliant, and in particular that there are no provisions outright restricting the construction of ADUs. Use your best judgment in determining whether a restriction on an ADU is reasonable. For example, ensure that submissions comply with your governing documents, including any architectural guidelines, and that your architectural committee takes extra care in reviewing these ADU-related submissions. At the end of the day, if in doubt, consider erring on the side of allowing the ADU to be built and rented long-term. And again, just to emphasize, HOAs should not have any provisions in any of their governing documents outright prohibiting the construction of ADUs. Thank you for your time, and please feel free to contact us with any questions.
Thank you, Andrew. I see how there is going to be a lot of litigation in the future regarding what is a reasonable restriction and what isn't. And it's not a one size fits all, because every HOA is different. The properties are different. I can imagine a scenario where an HOA says you have to build your ADU in your backyard. But then what about the house that doesn't have a big enough backyard? Or, their front yard is a better location. Then do they get a variance? Is there some dispute process to deal with that? I feel like there's going to be a lot of questions and ambiguity in how an HOA can apply that going forward.
Yeah, absolutely. And you bring up a good point. What happens if an architectural committee is reviewing an application, a neighbor objects on the basis that they don't want it where it's currently supposed to be, they think they could go in another area? Would the HOA would it be reasonable for the HOA to deny the application and require that the applicant move it to somewhere else on the property? So there's so much up in the air, and it's such a subjective issue that, it's really hard to tell whether, anything is right or wrong at this point. So again, got to use your best judgment and do your due diligence on these ADU applications.
Yeah, and then another good point you made is that how, right now an HOA is designed with a certain amount of structures in mind, and they're going to assess their monthly assessments based on how many homes there are, how many units or lots there are. And if all of a sudden now let's say there's an HOA with 50 homes and every single home builds an ADU and rents it out, now you've got 100 residents in this HOA as opposed to 50. And how do you deal with that in terms of, trash pickup and water and parking and, access to in and out of the HOA, who gets the gate code? I mean, it's going to potentially, any HOA could double in size if everyone built an ADU. And let's say there's 3 adults living in the ADU, and now you have 3 vehicles attached to that. So, and imagine if every single home in the neighborhood does it.
Right, and we touched on earlier on in the presentation that one of the things that the state's looking at as a benefit of ADUs is existing infrastructure. Well, the flip side of that is that by adding more people in, you're taxing some of the infrastructure already in place. So how's that going to work out at the end of the day? And in particular with HOAs, where you not only have that but common areas, it's going to be a touchy issue.
Yeah, and then does the occupant of the ADU, do they have any right to be heard with the HOA? Because technically they're not a member of the HOA because they're not an owner of a lot, but yet they reside there, and maybe they should have a right to be heard. I don't know.
Yeah, and if an HOA doesn't allow them a vote, or if it insists on assessing them, is either the renter or the ADU owner going to call that an unreasonable restriction? Possibly, we don't know. So it's quite the catch-22 for HOAs.
Well, it's very interesting subject matter. So thank you, Andrew. And as Andrew said, if anyone has any questions or would like a copy of the slideshow, please feel free to email Andrew or myself, and we will respond as quickly as we can. Thank you.
Thanks, everyone.